Cristina Caffarra, thank you very much indeed for your availability.
My pleasure.
You have a very authoritative, impactful, and eloquent voice in the area of competition law and digital economy and other areas of competition law as well and policy. And I thought that I will use this opportunity trying to kind of to go a little bit deeper into your main ideas, which you share with different events over the last year or probably last 2 years. And you are known as kind of as a protagonist of the reform in regulation of digital markets in this competition policy sensu lato. But at the same time, you are quite skeptical about its kind of measurable, deliverable outcomes of the reforms. And once you said that big tech will manage regulation, a little bit of fairness on the margins, so there will be some incremental improvements, but people who are expecting somehow revolutionary changes with entrance into force of the DMA and probably UK equivalent are over-illusioned. Can you elaborate on this, please?
Thank you so much for your nice words, Oles, and it is a pleasure to be here. Let me start with a disclosure, because I need to make disclosure every time I speak publicly. I'm quite religious about it. I think that people should disclose their interests. Everybody who knows me knows that I've been in the private sector as a consultant for over 25 years. So I need to mention that I've worked adverse to Google and Facebook on multiple cases for regulators, for private companies. And I have done work in the last 3 years for Apple, Amazon, Microsoft, Uber, Netflix, and others. And I think it is important for people to disclose the work they've done, in part because, of course, it does give you a sense that I'm reasonably unique in terms of the experience that I have in the digital space, but also because, of course, people need to be able to place what anyone says in context and judge for themselves. To your question, let me start again with another statement, which is I think we're much better off potentially with regulation than without. And one of my sort of normal themes that are pursued over the last few years is that unfortunately antitrust has not been a success, not because the cases weren't good. Some cases were better than others. Some cases were good, some less good, but not because of lack of effort on the part of the investigating agencies, but simply because when you look at the outcome on the ground, the change has not been there. We haven't seen antitrust in any way materially change the status quo. So then, as we all know, we pivoted to regulation because it is effectively complementary instrument. It's not a substitute, we all know that, but this sort of strong sense was we need a regulatory tool to be able to discipline some of this conduct ex ante. My skepticism, and it isn't a skepticism of the tool as such, but it is again focused on what I think is potentially achievable here. In a sense, antitrust failed because we intervened too late. Every one of the cases that we have done has started too late, has taken too long, and led nowhere in terms of remedies. Regulation is also starting very late if your ambition is to bring about changes of some significance to the structure of these markets. So these cases that motivate fundamentally the structure of the regulatory tool are cases that we know about. They are somewhat intended to make sure that the platforms do not go too far in self-preferencing and various other conducts. But the fundamental question is, what can we hope to achieve? And I remain of the view that although this is better than not, and indeed there are signs that the regulators, the Commission, is gearing itself up to dedicate some more significant resources, to dedicate some more significant assets to this. We are in a world in which we are facing with levels of market power that are absolutely enormous, and they will not fundamentally be undermined by this. Now, I do not think that the objective of antitrust is necessarily to undermine market power. The objective of antitrust is, of course, to deal with conduct. But when you have companies that are so large and pervasively large and so expansive in a number of places, if you think, as some of the progressives are certainly thinking, that one should also disperse some market power to some extent, allow for entry and for some reduction of that current power, I think that that is very hard to achieve through this regulation. I think this regulation can intervene in a way that can make it more possible for dependents on a platform to receive fairer treatment. So if a platform is unfair to you in the way it discriminates you, in the way it gives you access to some of the tools, that is something which can be targeted. The notion that through this regulation we can necessarily or can hope to create entry that challenges the market power of this platform is unrealistic to me, because you are not going to see entry that challenges these platforms through this regulation fundamentally. You will see some intervention, and I am not saying this is not going to be welcome. The intervention is welcome, but there is a sort of a folk tale in these circles that but we know that the challenge comes from complements. We need to allow the complements to enter the market. Well, good luck to all of us, because I think that the time in which that was a potential outcome has passed. We have levels of market power that are so entrenched that I do not see how anyone will be seriously challenged in terms of an alternative platform being created through this regulation. We will manage the worst phenomena of exploitation, of discrimination, but it will not create a different structure. For that, you need something else. And don't ask me what it is, because it is a difficult question. Or ask me, but I don't have an answer.
So basically, you think there will be more fairness and contestability, and it will be more refined version of platform to business regulation, more advanced, more robust, but still not the structure of the market is unchangeable and unchallengeable, because it's a little bit too late. We often hear, we often hear from European enforcers and other members of the Commission and other bodies that maybe the next important issue is industrial data and all this cascade of regulatory initiatives which would supposedly allow European Union to have a more strong position in the future kind of industrial revolution. Maybe they want to mitigate this kind of lost battle to consumer data with regard to industrial data. Could this explain the current mood?
Well, I mean, there is no question that all of these things are potentially of interest. I mean, Europe doesn't have platforms, doesn't have cloud. It is concerned about resilience of some of this infrastructure when it comes to our data, for example, being held somewhere else. But I mean, the reality, and this is also the reason I'm skeptical that this regulation can achieve much, is when you think about the investments that are needed today to be a serious player in this place, they're so huge that only actually these players can afford to make these investments. If you are Facebook and you're investing in, or Meta, if you're investing in the metaverse, the only one you're scared about is Apple. You don't, or Microsoft maybe. You're not scared about anyone else. You're not scared that anyone can come and challenge you on your ambitions in the metaverse, because you know that the investments in technology that need to be made in order to be a player in this space are so large that only companies with this level of sophistication and backbone can ultimately make it. And it is a conundrum, because we are in a way in a world in which, where is competition to meta in the metaverse going to come from? It's not going to come from a new entrant. It's going to come from the other players who are in a circular firing squad and they're all shooting each other. Is it competition? Of course, in a way it is, but it is still the same players. So again, if we are content with the notion of competition in which you have big giants fighting each other, just grabbing chunks of each other, that's one version. But if we have, I think, a naive version of competition growing from the bottom and somehow being fostered by some sort of vague notion of contestability, that is incredibly naive. Who is going to be, through a contestable provision, going to challenge the investment that need to be made to be serious player in this place? No, people can make apps. They can make little app stores. You can place your little app stores A and B, but it isn't going to be a challenge to the incumbents. And that's where we are. I'm not suggesting that this is something we need to sort of necessarily go and do, but it is also a realistic take on what I think regulation can hope to achieve.
Well, obviously, a comfortable, not very convincing, but still structurally comfortable response for this would be, okay, it's our mission as regulators of the model to enable the new entry, to facilitate the new entry, and it's not for us as regulators to engage in micromanagement by somehow facilitating the entry for specific companies, particularly if these companies are European, and particularly if they are somehow, if they benefit from strong public investment, etc. But I wouldn't be particularly convinced in this argument. But assuming that regulators care about the structure, so by bestowing such rich obligations and competence to the Commission and obligations on the gatekeepers, still, full of adjectives and thus open-ended to a large extent, we somehow infer that there will be a regulatory dialogue between the enforcer and the gatekeepers in terms of calibrating, fine-tuning, refining the essence, the scope of these obligations, particularly as far as Article 6 is concerned, but we also understand that Article 5 will be affected as well. This leads us to the thesis of participative antitrust, and we understand that it requires participation on one hand, but there are many challenges and obstacles and shortcomings related to this participative model. And you've been also not very critical, but you provided this healthy skepticism and kind of eye-opening reflections about the convenience of the participative antitrust for those for whom the model is basically designed.
Again, this is a difficult one, because I think that agencies, given the asymmetry of information that they suffer from, are not going to come out alive unless they really are able to enable themselves to a very significant extent with technical capabilities. They're not going to come out alive in any confrontation with any of these players because their technical competences are so superior. So any one of them can run rings around your standard regulator, unless the regulator has got, as I say, capacity and capabilities of its own. So we're hearing that the Commission, much as the CMA, indeed also the DOJ, we heard Susan Athey the other weekend, are enabling themselves with greater technical capabilities. But I think that to have a level of dialogue and discussion is required, because at the moment the gap in knowledge is too big, and you need to some extent the companies to fill it. The regulator is not in a position at the moment to make informed decision on many of these issues. On the technical issues, they're completely in the dark. So you need to somehow think of an incentive compatible mechanism of sort, whereby you as a regulator can engage in a constructive dialogue with these companies. Otherwise, somewhat, I'm clear that the general posture will be, they know nothing, they don't understand anything, pointless to talk to them. So there needs to be some level of learning and incentive compatibility to induce the companies to share some of their learning and knowledge. That said, I'm also a critic of that because I think it can go too far. It can get into a comfortable salon in which, you know, people reach a level of comfort with each other. And this is both, and then a level of self-satisfaction, which is both undeserving and unbecoming. And so I think, you know, there's need to be a bit on guard because, of course, this idea of participative taken too far becomes regulatory capture. On the other hand, as I said, I do worry about the fact that the knowledge is so different, and unless we create structures in which companies have ultimately some form of incentive to cooperate and to share knowledge, then it's hard to see how progress can be made.
But if you look at the mechanics of the DMA, it's one of very few regulations where it came from the Commission being very strong, and it's supposedly being even reinforced by the Parliament by adding a little bit more of obligations, by expanding the scope of core platform services, and elaborating a little bit on some procedural aspects. So we can somehow infer from this that those people who really wanted to grant the enforcer as much competence as possible would diminish the standard of proof to a very low level, and shifting the burden of proof essentially to the gatekeepers to demonstrate that they actually didn't do something which is prohibited, or that they complied with obligations. Even in this situation, you think it will be very difficult, it still not be very workable? Is it not workable because we don't know the final goal, the thing which we started with? What is our common denominator? What would be the benchmark against which we compare this? Or it's not workable because of the technicalities and the super well-equipped lawyers and economists working for the defendants?
I think, and I've made this observation before, you have a set of rules that are what they are, and they sort of derive from a rubric of antitrust cases, right? But when you introduce something like an obligation not to self-preference without much further qualification, then you immediately run aground, because the question is, what does self-preferencing mean in the context of different business models in which, as I've said before, the incentives are very different? And it's not just me saying it. I mean, the court has said it in Google Shopping. The General Court has said that there is self-preferencing and anti-competitive self-preferencing, right? And the fact that you may select one of your products to be featured, for example, doesn't necessarily mean that there is anti-competitive conduct. There needs to be more than that. It needs to be the case you're using data, for example, you're not supposed to use from sellers in order to make that recommendation. Or it must mean that there is a sort of a thumb on the scale that when you have churned your algorithm, you are producing a recommendation which is not exactly the one that is based on objective criteria of price, quality, and satisfaction for the consumer. How are we going to figure that one out? Unless we have some visibility into algorithms, for example, how algorithms are structured, unless we understand how recommendations are made. So to me, it's all very well to have a rule that says you shall not sell preference, but self-preference is very different in the context of a funded business and in the context of a transaction platform. And without further specifics, it isn't clear to me how you're going to go from the general rule to something which actually works in a particular case. So that is really what it is. And if you have no ability to, in a world of AI, machine learning, to have the faintest idea of what these algorithms possibly do, what you do? What you do? So you say, thou shalt not sell preference. No, promise, I won't. How do you actually detect that? That's the gap in knowledge that you as a regulator suffer from. And you need to somehow work out how in the particular circumstances of a particular platform with their business model, you are going to actually identify self-preferencing. That's why in all of these cases, the Commission has gone for some escamotage, some kind of side turning. I mean, the Amazon case on data was about exclusion. No one was being excluded there. But of course, there is case law that kind of one can latch on to, and then you don't have to answer the more fundamental question that says, but are you actually meaningfully using this data and is it exploitative? That's the question, not foreclosure. So you see, if you don't understand the underlying technology and what's going on, it's all kind of a hand waving. Is the fact that Amazon recommends a particular product in the buy box and it's an Amazon product self-preferencing in and of itself? It surely is not. It depends on whether that recommendation is based on objective criteria or not. How are you going to tell if you don't know what's in the algorithm, how the recommendation is being surfaced? That is my point. So how are you going to conclude that something is not self-preferencing? And even if the company tells you, we don't have any kind of thumb on the scale, you know, it's the question. How are you going to satisfy yourself?
So basically, you think that not much would be changed in 6 months, and that there will be still procedural limitations and pitfalls which would be somehow used by the defendants, and there will be
no. I mean, there are distinctions to be drawn here. I mean, we now know what the timetable is, and everybody's still discussing designation, right? They're still discussing what's in, what's out, what's in, what's out, and discussing what can possibly be eventually subject to the obligation, right? And some of it is going to be market tested. So some of it is going to take time, but then you'll get to the obligations. And I think my understanding, and I think this is the general understanding, is that the companies need to proactively make proposals on how they're going to propose to comply with the obligations. And at that stage, there will be inevitably a dialogue about whether these proposals are satisfactory and they work. But what I'm saying again is, unless you have the competencies internally to gauge what the solution is, you know, look at the history of the antitrust cases. You know, look at the Android story. I'm simplifying, but in Android, the first versions of the remedies were simply not serious, and it took forever to figure out that they were not going to do anything. Not that the second version did much, or the third, but you know, the point is you need to really have the competences. The CMA eventually approved of the Google Privacy Sandbox after very lengthy engagement with Google on technical aspects of the proposal. And so the point is, unless you have that ability to engage on the technical side, and I know that the privacy regulator was involved, the CMA, data scientists were involved, what do you do?
Let us move then to the issues of privacy and its correlation with competition policy. It's a big topic these days, we all understand it. And we see somehow two completely different attempts to address it from the perspective of exploitative abuses and exclusionary conduct as well. So they obviously are motivated by the same idea to somehow to tame, to domesticate, to bring some order into this, omnipotent universe, digital universe. But exploitative concerns deal again with rather, I wouldn't say marginal issues. When you used your analogy, which you did with Google search some time ago, that price comparison websites are important, but they are never existential and they are not at the core of Google's business. In the same way, one can argue that for Meta, the ability to combine data with some websites which are either owned by Meta or not, it's important, but they know already a lot. So it wasn't kind of an attempt to use the existing vocabulary, the existing case law, and the existing understanding. That's one, and very meritorious, of course. And another, probably much less discussed aspect is exactly the issue related to privacy sandbox. When we're talking about big tech, who essentially say, okay, you care about privacy. Now we realize, we didn't realize it before Cambridge Analytica, etc. Now we understand that the society really do care about privacy. We will be your guardians, actually. We promise to design the system which will protect you as end users from all this, hungry mavericks who somehow cross all imaginary lines, and we will disintermediate you from them and create a kind of civilized system which essentially will be somehow, by removing third-party cookies. That's the ethos of the proposal. And where are we in this respect? So we have two different antitrust modalities and two different responses to what sounds prima facie as kind of competition and privacy, but we have two different avenues here, don't we?
Well, as you know, I have been agitating and campaigning for some time for a less siloed approach, an approach in which both the data protection agency understood that the problem that they faced is a problem of market power as well, and leaned against the antitrust agencies to work collaboratively, and a position in which the antitrust agencies understood better the role of data in creating and cascading market power from market to market. So I'm a big fan of an approach that is more integrated. Now, I think you can argue, I'm not a great fan of Google, as people know, but Privacy Sandbox is a proposal that was vetted by the CMA for a lengthy period of time, an ICO, and it came to the view that that was acceptable. And I think that, to some extent, some companies are beginning to recognize that data protection and privacy are important to people and will take initiatives in that direction. So Apple has done ATT. Now, the question that Apple is facing, Apple tracking transparency, is whether that is an initiative that is in itself a form of self-preferencing, because it does confer on Apple an ability to see and to track, to some extent, iPhone owners in ways that are not available anymore to third parties. Is that a form of self-preferencing? Is there a shift in advertising towards them? Is that a problem? And these are important questions where you cannot have just an antitrust regulator trying to come to grips with this, because an antitrust regulator working with our data scientists, without deeply understanding what's going on inside and what effect the data flow change has got on the ability of advertisers to effectively sell and track the efficacy of advertising, will be totally clueless as to what is happening here. Which is why I think that many of the actions that are out there that are claiming self-preferencing are uninformed. And I think there is a lot of more work to be done that needs to come from importing tons of data scientists into this discussion. What on earth is going on? The economists and the lawyers haven't a clue about how to diagnose this and how to to stand by it? What value are we inputting? So Apple is doing something that objectively improves people's ability to choose their privacy. How do we value that in the equation? And how do we actually take the view that that is offsetting some of the potential self-preferencing? So these are important key questions. You can't have just a complaint and say, well, I can't see this anymore and it is affecting me. Well, there's a number of parameters there. And my concern is that, you know, competition regulators are beginning in some places so in France, for example, sure, the ADLC is speaking to Canal, and there is quite a collaborative, but it is still incipient. I think in this area, there is a lot more collaborative work that needs to be done. And it's not just collaborative, it's really kind of focusing directly on what matters, which is how are we understanding this? My campaign has always been, well, I think economists are completely lost and lawyers even more. No one has the faintest idea about how to gauge what is going on there. So what are the competition authorities doing?
Do you think it's purely technical, lack of purely technical understanding of the kind of data science, or it's also kind of, we have to acknowledge the more political and thus more discretionary role of antitrust agencies and their links with broader societal or, let's say, governmental agenda? Because it's a discretional, it's not scientific, it's not measurable, or some of these parameters are not measured. They are measurable by data scientists, but the issue can be simultaneously pro-competition and anti-privacy, or pro-privacy and anti-competition.
But then, so what are we going to do? Are we going to sit on our hands and let the competition agencies kind of do some random stuff? I mean, my worry is that unless you understand these things and you have a deeper understanding of what is going on behind, the quality of the judgments that you make as a competition agency are superficial by definition. You're not understanding really what you're not understanding what is the actual profound impact of what people are complaining about. And so we have privacy washing versus self-preferencing, which is which, you know, because we have all of the complainants who are privacy washing. So who are accusing these guys of privacy washing, and the others are saying. So you see, is it privacy washing, or is it something which has got substance? How does it
shouldn't necessarily be either or? Maybe they coexist, these two
Oh, absolutely,
strategies.
absolutely. And do we so exactly right. How do we think of the trade-off, if at all, between these things? Because suppose that you have a practice that is objectively improving the ability of people to preserve their data. And that practice also has the effect of perhaps driving some advertising revenues to you. So how do we actually gauge the relative value that people put on bigger privacy and the fact that some alternative advertising platforms may have lost some of the ability to track, and therefore they cannot do things quite as targeted? I mean, it is a big set of moving pieces here. But we can't just say that because you adopt a particular policy, you know, objectively it may benefit you because you have visibility that others don't have, but you are making also value judgment about the value that people attach to privacy and being able to make choices. How do you factor that in?
Cristina, we are approaching the end of our conversation at probably one of the most interesting kind of periods of this dialogue. And at this point, I wanted just to arrange these two issues, if I may, to provide us with tentative agreement to continue this conversation at some point in the future, A, and B, maybe from your experience, being on the top of the profession, observing different trends, behavior, maybe you can share with our viewers, students, some golden rules, some golden tips, some recommendations which they should be aware of this entering into the profession in such kind of really challenging and really interesting period?
So one recommendation that I would make, for what it's worth, is not to think that everyone right is on this side and everyone wrong is on the other side. Okay, so when I discuss my own personal approach to this, is that I've learned and understood a lot of things from talking to companies and working for them that I would not have understood being outside and just shouting at the moon. So there is something to be learned in, a lot to be learned in understanding incentives and businesses. And so when you're thinking about these issues, trying to also think about what is going on, and in a bigger sense, not stop at, you know, they're so powerful, they're so big, we need to somehow knock them down, because that isn't a useful discussion. It isn't a useful discussion. These companies are not going anywhere. And it isn't a useful discussion to try and dethrone them. I think it is a useful discussion to try and think about what other perhaps forms of regulation or intervention could facilitate or somewhat stimulate some sort of challenge, some sort of alternative, additional players. Now, I am a skeptic of interoperability personally. I don't think it goes very far. I know others are very keen on interoperability. I think it will be one of the tools that's going to be used. I worry that we sit in big rooms like the standard setting organization, and he says that, and that says that, and that says that, and nothing gets resolved, but we will see. I don't know. I would invite people to be not always, you know, thinking that the reason is all on one side, to try and understand the business motivation and the bigger picture that explains how people behave and what choices they make in business.
Cristina Caffarra, thank you very much indeed for sharing your thoughts with us. It was a pleasure talking to you.
It's a pleasure. I hope to be here again another time. Bye-bye.
I hope so as well. Bye-bye.